Hello and welcome to Legal Angle. Redevelopment is an issue faced by many Mumbaikars. In our previous episode, we have discussed about redevelopment. But as we are going forward and forward, we are finding many more issues rising by the day, for which we need an expert legal advisor for the same. And today, at this hour, I have a practicing advocate of DM Legal Associates, none other than Miss Ankita Verma. Welcome to the show, Miss Ankita Verma.
Thank you.
As a legal advocate, you have many clients. What are the problems of these clients when they come to you? Especially, what are their grievances?
As regards redevelopment, the
Yes.
first and foremost thing that people come to us is not getting majority consent. So how do you go ahead with the redevelopment when you do not have 75% consent?
True.
So that is the first and foremost step. The second thing that people come to us is while signing of the redevelopment agreement, there are a lot of terms and obligations that are mentioned in the agreement. How do you actually implement those? The developers face an issue that the members do not vacate. The members face an issue that the dissenting members, that is a minority, do not cooperate in the entire scheme of redevelopment. Moving further, while the construction is going on or anything of that nature, there are times when there is inordinate delay on various grounds by the developers.
Like, what are these delay by the developers?
At times, raw material is not available. For example, probably 2 years back, there was a shortage of sand.
Okay.
जो हम रेती and all those things had to come in. There was a shortage in the entire Mumbai market.
Correct.
People weren't getting raw material. How could they construct without raw material? So there was an inordinate delay. Then at times during the stage of construction, a lot of things come through. For example, there is an area in Juhu which is governed for military substation space. So you cannot develop beyond a certain height in that 500 square yards of area.
Correct.
Now there was a society the building of which was demolished.
Correct.
Necessary sanctions, approvals, everything was in place. Achanak se, while the plinth was being cast, the military authorities got to know that okay, there is a building that is coming beyond the restricted height, and therefore a stop work notice was issued. Now the members are already out of the societies, out of their houses. The developer is going on paying them rent. After a certain point of time, the entire project becomes unfeasible. So these are the kind of problems which a redevelopment project on a day-to-day basis faces.
Now that gets me to a very crucial question here. Why does a local mass suffer because of a developer? Now you have given a very good example. You have spoken about shortage of sand. You've spoken about area restrictions in Juhu. Why does a member face these problems after taking that risk and giving his own property to a developer? Why do these problems arise later, and how can one tackle these issues?
The first and foremost thing would be to know your area well. These kind of issues won't arise if you know your area well, if you know the zone you're falling into, if the PMC is guiding you well. But there are many a times the developer here is not at fault. If there is a shortage of raw material, there is nothing the developer can as well do. Plus, if there is a notification that comes up out of the blue, which nobody is actually aware of, what can the developer do? So it is best to research on the area where the development is taking place. It is as much as your responsibility as it is the developers.
Yes, it becomes a major responsibility of a developer.
Yes, it is a joint thing.
I would love to tell my viewers that, when they go in for a redevelopment process, they have given everything to the developer in consultation with the PMC, that is the project management consultants, as discussed in our previous episodes. But now that they have given the entire property to them, and now there is a major delay, that is hurting the end consumer. So for that, we need to tackle a solution. And as a legal advisor, what would you suggest our viewers?
The first thing is while entering into the development agreement, I have always stressed this to my clients, the cooperative societies, members of cooperative societies that come to us, is we should always take these contingencies into consideration while going for redevelopment.
Absolutely.
That's the first thing. Second thing, always make sure that your rent, you are secured with your rental part of it.
Correct.
So that you do not need to incur additional expenses.
Correct.
So while you are in transit accommodation, you need to secure yourself. So if you are taking in advance the first 12 months check,
Correct.
make it sure that you get the next 12 months check in advance in the 11th month itself.
But what if the developer fails to give the 12-month check in advance?
You always have recourse. You can go ahead for specific performance.
What is this specific performance
Specific
like?
performance is basically whatever you write in a contract. It is legally binding upon both the parties who are entering into the contract. So the party aggrieved can approach the court and ask the court to direct the other party to specifically perform the contract.
Okay.
Whatever is binding upon the other party needs to be performed.
Okay. So now that the member is getting into the court action, the court scenes, how can the members' work get more easier? Like, usually as a layman, there's many processes when he enters the court, the legal system. Why should so many members in a society suffer because things are going late? What would be your advice for this?
As I insisted, the role of the PMC is extremely important.
Correct.
Because he takes the society through the entire process of redevelopment. But what needs to be taken into additional consideration is, as a PMC is an extremely important part, you need to have a very good lawyer to safeguard your interests in the first place.
Wonderful.
Litigations in this country are not easy.
Wonderful.
And they are pretty time consuming.
Wonderful.
So if you have a legal expert who can actually take care of your needs while the contract was being executed, you will be saved a lot of hassles.
So our viewers, we have come to a mutual agreement that you first need to have an expert PMC on board, right, Mrs. Ankita?
Yes.
An expert PMC on board that can suggest you with how you can go about your process. You have to research your area well. This is what Ms. Ankita says. And finally, the property will have no hassle if you go through all of this in your proper stages. Well, we are going to take a short break and we are going to be back. Stay tuned on Spin TV because we are going to have more on this issue. Welcome back to Legal Angle, and we are in conversation with Advocate Ankita Verma on issues of redevelopment. Well, Ms. Ankita Verma, can you also tell us the benefits and demands a member can make while vacating the existing premise?
While vacating the existing premise, the first thing is the corpus fund, the hardship compensation, which is known. At least normally this is the trend that 50% of the hardship compensation is given at the time of vacating the premises. Second thing is rent for the transit accommodation. When you are leaving the accommodation and going, it is obvious that you will be taking up a place on rent somewhere in the nearby area.
True.
So the transit rent for the period of development should be demanded. The third thing is to find that transit accommodation, you'll have to pay brokerage. So 1 month of brokerage is the general trend which is given by every builder to the vacating tenant or the member of the society. The fourth thing is shifting charges. You need to take your luggage and go to the other place.
Correct.
So shifting charges is also something you can claim for the developer.
Oh, the developer would take the shifting charges? I mean, would he bear the cost on him?
They generally do. This is the trend that is going on.
Correct.
It is of course subject to the discussions and the agreement between the members of the society as well as the
Correct.
developer. The fourth thing which should be stressed upon is the bank guarantee, which will provide security to the residents that the construction, the amount which will be used for construction will be lying in the safekeeping, and if the developer is not able to complete the project for XYZ reason beyond the stipulated period, or he has abandoned the project, then the bank guarantee can be invoked. The members of the society can appoint their own contractor and go ahead with the development of the entire building.
How can we note the stability of a developer? In a sense, you've mentioned that a bank knows the developer, but in today's scenario, a developer has 4 to 5 multiple redevelopment projects. So an end consumer would just look at the developer and mention that, oh, since he has 4 to 5 projects, he is a safe developer. But is that the criteria to get a safety or a stability of a developer?
It is very important for the members not to just rely upon the offers which are made by the developers.
True.
They need to do the background search. If we are going ahead with any kind of investment, or if we are going ahead with any kind of, take for example a simple shopping, we look at 10 products and then choose one.
True.
Right? Which we think is the best bargain.
True.
But what do we see? We see the quality of the thing.
Correct.
Similarly, a similar process, due diligence, needs to be carried on the developer as well.
Correct.
So the first thing you have to check is, right, how many projects is he handling? How many projects has he completed? Since how many years is he into the construction field?
Correct.
So when everything is in order, then you can safely rely that a developer wouldn't put his reputation on stake for merely some money or some
Correct.
amount. Until and unless grave situations arise, he won't be abandoning the project because he has a reputation in the market.
Correct. So viewers, you should first check the developer. His stability makes viable only if he is in the industry since a very long time, and also if he has done marquee projects, and also his funds. Well, Ankita Verma, we would also want to know the special rights a society and a member can avail, the protection rights and a guarantee, a surety that they will get the project on time.
The general trend is the developer furnishes a bank guarantee to the society while they are vacating their premises.
Okay.
So when the bank guarantee is furnished, it makes sure that if the developer doesn't complete his obligations under the development agreement, within the time stipulated, the members have the right to invoke that bank guarantee.
Can you highlight a bit on this bank guarantee? Like, what is the bank guarantee process with which a member gets indirect earn?
What happens generally is when a bank guarantee is being furnished, it's important to understand what is a bank guarantee.
Correct.
It is basically an undertaking by the developer that I'll be completing your entire building. And for that, if I do not do that, then I'm keeping so many funds reserved for this project so that if I default, you can go ahead and complete the building with those funds.
Oh wow.
So the amount of the bank guarantee is again subject to agreement between the builder, developer and the members. PMC has a major role to play here as well, because he can suggest as to what will be the amount required as bank guarantee.
Correct.
Now this is generally again according to the trends, it's of a diminishing nature. So if you complete the plinth level, a certain amount will be deducted and it will be going back to the developer. It will the bank guarantee will keep reserve for the unfinished work.
So what if the developer comes to the 30th floor? He's almost finished all the guarantee. The funds are almost in his favor. So what remains for the end consumer then?
But whatever the unfinished job is, for example, the building is of 30 floors.
Correct.
He has completed the 30th slab. There is a part amount which is reserved for the OC as well. So
Okay.
that amount is released only after the OC is obtained. Certain agreements even have terms like a certain amount of bank guarantee will be kept till the next monsoon, so that the members can point out defects in construction quality if needed. So this is the way in which a bank guarantee functions.
Correct. Now, with regards to bank guarantee funds, does it fluctuate with areas like, for example, South Bombay, or when we come to the western or a central So does it fluctuate in different areas?
It will definitely. It goes upon the cost of construction.
Correct.
What will be the amount required to construct that much area
Okay.
is what the bank guarantee is determined on. That's why I said the PMC, being a technical person, he is in a position to judge what will be the amount required for that area as regards to the construction which needs to be done.
All right. So viewers, we know about bank guarantee in detail now, and when we come back, we are going to discuss about processes of negotiating with a developer and making your rights and privileges in a better way. We're going to take a break and we're going to be back soon. Stay tuned on Spin TV. Welcome back to Legal Angle, and we are with practicing advocate Ankita Verma. Well, Ankita Verma, we would want to know, while negotiating with the developer, what are the common mistakes made by the society members?
By the society members. Generally, we see that a redevelopment committee is constituted to negotiate with the developers. There are many cases wherein the redevelopment committee, for personal gains, does not negotiate, sacrifices on the interest of the society.
Correct.
So this is one major thing that everybody needs to be kept in loop as to what are the negotiations going on, and it is always better that you get appropriate resolutions passed by the entire society as regards all the negotiations. Otherwise, the major problem that a society faces is internal issues.
Correct.
A lot of people will come ahead and say कि ये सही नहीं हो रहा है, जो हम लोगों को चीज़ें मिल रही हैं वो सही नहीं मिल रही हैं. So these are the internal issues, are the major factors which play while negotiating.
So you're trying to tell me that even the redevelopment committee that has formed, all the members have to be bonded and united for a better output.
Yes.
Well, going by a better bonded strength of the redevelopment committee, what are the major issues faced by the developer from legal angle when he deals with the redevelopment committee of the members of the society?
By developers, generally the first thing is the members, the redevelopment committee will say कि okay, we are so many people who are for the development, we are 75%, but we do not take any responsibility for the dissenting members. You deal with them however you want to.
Correct.
Right? So the developer goes ahead and deals with it. But the problem is then they want it in a particular time frame as well. From a developer's point of view, if a developer has to pay probably 5 rupees for a negotiation which might take a bit of time, he has to pay more than double the amount if he falls into pressure of the redevelopment committee.
Okay.
Which makes the entire project non-viable for the developer.
Okay. Now we are seeing many issues that are coming on the way of redevelopment. So this is something out of the box that I want to ask. Will a government regulatory authority body was already planned to come on board? Will it benefit redevelopment on a mass scale?
Basically, now guidelines have already been formed in 2009 regarding redevelopment. This was done because there was no transparency. Now they have given us a guideline which needs to be followed, which specifically says a committee needs to be appointed, specific resolutions.
Does this revise every year, or it is standard since 2009?
There is a standard set thing done.
So it keeps revising?
Yeah, I mean, there is an amendment to 79A of the Maharashtra Cooperative Societies Act to include the provisions for redevelopment as well.
Can you stress on that amendment, 79A?
Now, 79A of the Maharashtra Cooperative Societies Act specifically says ki 75% is fine.
That's
you don't need to have an absolute majority. Second thing, it provides for redevelopment committee. Third thing, it talks about necessary resolutions being passed so that there is absolute transparency in the entire system. As I said, that the rights of the members shouldn't be compromised for personal gains of few.
Correct.
So it keeps a check on the entire process.
Well, if the developer promises a a project, if he gives a very rosy picture about the things he's giving, but fails to deliver, what is the legal action that can be taken on the developer by the society members?
Generally, when we are signing a development agreement, a list of amenities is attached to the development agreement. The developer specifically specifies all the things that he will be giving.
Okay.
So if he is giving a swimming pool, he will be specifying that. In fact, he will be even specifying what quality of internal fittings will he be giving.
The CP fittings.
Yes, exactly. So the member has the option of approaching the court for specific performance of the contract, as well as he can also approach the consumer court
Okay.
for deficiency in services provided.
And any idea how long would the court take to rule out the matter and give a proper judgment on this matter?
Litigation, with litigation we cannot specify a time frame as to this is the time it will take. Generally, we would say an estimate of 3 to 5 years.
If you're saying an estimate of 3 to 5 years, will the developer again give rent for 3 to 5 years?
We are talking here about amenities. If he is giving the flat
Correct.
with
No,
an
if
OC.
your flat is not hand over to the residents and now there is a dispute, so will the developer give the rent?
Till the time the OC doesn't come and till the time the builder doesn't offer possession of the premises to the members, it is written in the agreement that he is bound to pay the rent to the members.
Are there chances when the OC and possession is given, will there be any disputes with the developer?
If everything is in accordance with the sanctioned plans, there shouldn't be a dispute.
Okay.
So if the developer is completing the entire thing and then offering it for possession, and still people are not accepting possession, in that scenario the builder won't be, the builder or the developer wouldn't be liable to pay the rent because he has already offered you possession. You can move into the premises. So you can shift in and then initiate legal proceedings against him. As I said again, there is a particular amount of bank guarantee which is kept.
Correct.
So you can have provisions in the bank guarantee for these amenities as well. Whatever has to be given, you can invoke your bank guarantee for it.
With regards to once the redevelopment project is signed by the members and agreed on a certain value, could there be any hidden charges? As a legal advocate, I'm sure you're facing hidden charge as an issue. So if you could tell our viewers in depth about hidden charges involved when the negotiation process is on.
Generally, the stamp duty registration is paid by the developer.
Correct.
Second thing, it comes to when the society, when the members shift in. At that point of time, they have to incur several costs.
Okay.
For example, 12-month maintenance, electricity meter deposit, water meter deposit, legal charges that a developer might put in the agreement.
Correct.
Everything, all these costs are subject to the negotiations. However, a member should definitely stress that all the hidden costs are actually covered under the agreement. No extra money shall be charged.
We have a last question for the day. If the dissenting members are not agreeing with the redevelopment project, what are the options available for them?
Well, the first thing, the dissenting members can hand over the premises to the developers on an agreed rate and move out of the premises. Also, if 75% or more of the members are agreeing to the redevelopment of the building, then the developer along with the members can approach the court. In fact, there have been instances where the High Court has ruled. For example, there was a case of Raja Builders.
Okay.
And also with Vardhaman Developers, where the High Court had ordered that the flats of the dissenting members shall be taken over by the court receiver, and the building, the premises will be handed over for redevelopment to the developers.
So technically he only can hand over the project to the developer.
Yes.
But what are the other benefits that can be availed?
by the dissenting members.
Yes.
They can sell off the premises to the developers, or they can sell off the premises outside and go ahead, because the whims of a few cannot affect the majority of the people.
Correct. All right. So in this episode, we have dealt with issues between developers and the society members, and we have also come out with solutions for the society members to make the process a bit faster. For this episode, I would especially like to thank Ankita Verma for helping us highlight solutions in a better way. So Ankita, thanks for spending your precious time with us.
Thank you so much.
We'll be back with our next episode on issues regarding redevelopment. Till then, stay tuned on Spin TV.